There we go. Hey, good morning. It's Jamie Miller from Miller and Miller, and I'm happy to have my partner in student loans, Christy Arkovich, on Facebook Live today. I really thank everybody for joining us. Christy is in beautiful, sunny Florida. For all of you in Wisconsin, we've had the most lovely week of 70-degree weather. Today appears to be the last day as we have a cold front coming through. So back to reality, 40 degrees tomorrow, probably snow not too far away. Christy smiles at that, of course. But we've just had just a beautiful run. We're going to talk about student loans. In particular, this is our second in a series of conversations about student loans. Our prior conversation was kind of just a general conversation about different types of student loans. And today we're going to focus on private student loans and kind of the changing landscape. And a lot going on. But just to reintroduce Christy, if you weren't with us last time, is Christy is a zealous advocate for consumer rights in the mortgage industry, in the student loan industry, and has helped tons of clients and is helping our clients navigate through the ever-changing landscape of student loans. She's author of the book, How to Take Your Life Back from Your Student Loans. A graduate, as am I, of Josh Cohen's student loan law boot camp. She's also acted on the other side for as trial counsel for Sally Mae and for Student Loan Services. So she knows a lot about what's going on with the prosecution and collection of student loans, as well as the what consumers can do. So welcome, Christy. I've probably talked too much. Tell me a little bit about how you're doing today.
Thank you, Jamie. Well, we're happy the hurricane is not hitting Florida. Looks like it's going out in the Gulf. Before we get started too much, I want to do my student loan sucks t-shirt. We've
Nice. I
just
love that.
yeah, we've just had tremendous success with identifying problems that folks have with their student loans, and it's really been a wonderful thing. We don't need an act of Congress to do much of what we do, and one of the nice things you mentioned, what's going on this week, obviously the elections, regardless of which party you are for or which candidate you are for. I think all of us are happy that we are probably going to not see Secretary DeVos in office any longer.
I know that's a great thing.
Yes. That particular person in charge of the Department of Ed has been a challenge in the last few years. And I think that we won't have that going forward, and that'll be very, very nice. Obviously, that's governing more federal loans, but even so, she and her department will have a level of protection for private loans that may not exist going forward. So I think going forward, we are sitting in a better seat than we are now, and I'm pretty pleased on where we are now and what we can do for clients. So I'm good with it.
That's great. And I see Hillary's listening in today. Thanks for listening in, Hillary. And we're going to be talking about student loans. If anybody would like to set up a meeting or a consult with Christy, we can take those consults today. 414-875-3816 is the number to call if you'd like to schedule a meeting. But Christy, what I want to talk to you about today, I meet with a lot of clients that have a lot of different student loan issues, and the biggest question is, what's the difference between a private student loan, a federal student loan, and oftentimes they don't know. So how can you talk about the private student loans and what consumers are
Sure.
facing now?
Private student loans, you can often identify those by a student loan list will show Stafford, subsidized, unsubsidized, direct FEL, all those kind of things. Those are federal misnomer or acronyms and such. At the end of the report will often show SIG, SIG for signature loans. They're also often on someone's credit report. Private loans have some features to them that make them easily for us to recognize that they exist. First of all, they normally will have a very high interest rate. Some of them will be in the 5 or 6 range, maybe even lower, but the vast majority are above 10%, 10 to 15% or so. And they often have co-borrowers as well. Federal loans usually do not have a co-borrower. It's very rare. You might have a Parent Plus loan that the parent themselves owe, but you won't have a co-borrower for 99.9% of federal loans. Private's the reverse. We often will have co-borrowers. There's differences between them, and that is the private loans don't have any governmental programs. There's no protections out there for them. So if you lose your job, if you have a lower income, there's no income-driven plans, there's no debt forgiveness, there's no public service. If the federal government passes something, it won't affect a private loan because they can't change the contract rights of the underlying party. So private loans and the borrowers are kind of left out in the cold, and it becomes a market for the unwary because most people, when they signed a private loan, they were 18, 19 years old. Even if they were asked to sign private loans as a junior and senior, what sophomore in college, even if they recognize that they're going down a path of non-sustainability and non-affordability on student loans, can they stop? You know, they've already signed off on half their loans. They've done 2 years of schooling. Who in their right mind is going to, put the brakes on? They're going to finish. They're going to incur the rest of those private loans, and that amount that they owe is going to be enormous. So I hope that answered your question on how to identify private loans and some of the differences on between them and federal.
Right. And so if someone has a student loan issue and they want to set up an appointment for you or an appointment with you, what are you going to do during that appointment?
Okay, great question. What we first do is figure out what loans they have. And we identify who's responsible for those loans, what the interest rates are, and identify if there's any way towards reducing the amount so that we can have a sustainable and affordable payment going forward. And we also want an end in sight. We don't like these 20 and 30-year plans. We'd rather have the loans done with in 4 to 10 years if we can. So we identify plans to do that. With federal loans, it might be taking advantage of certain programs that are available. With private loans, it might be to try to settle those, maybe strategically default in order to settle, maybe even take advantage of a former bankruptcy like we've discussed, Jamie, or filing a new bankruptcy because we're making significant headroads in getting rid of private student loan debt in a bankruptcy filing.
And so outside of bankruptcy, if someone has $25,000 in student loan with National Collegiate Trust, what are some of the success stories that you had with those types of student loans
Did you ask inside bankruptcy or outside?
outside of bankruptcy?
Okay, well, outside of bankruptcy, if a client comes to us, usually the lender wants $750,000, $1,500 in student loan payments. We're often able to reduce that to something that's more in the neighborhood of $200 or $300. So what we do is we say, all right, if you've got a mortgage payment that's in the range, if you've got a student loan payment that's in a range of a mortgage, let's drop it down to more car payment level. If you've got a payment that's around the car payment, like maybe $400 or $500, let's drop it down to maybe more consistent with a utility bill, what you might expect for one of those, 100 or 200. And we can do that in the vast majority of our cases, drop it to a sustainable payment. And then secondly, in our settlements, we're also paying no interest whatsoever. So the amount that our client is paying towards that debt is maybe 30 cents on the dollar, 35 cents on the dollar, but it's going only towards that principal dollar. There's no continued interest. So they actually can pay down the debt. Most of the people who come to us, they're not making any kind of headway on their loans. They owe just as much, if not more, than when they first started. So our success stories, there's no one in particular because it happens in most all of our cases that we're able to drop it that much. And then the key is if our client has just too much student loan debt, sometimes we have to do it in a bankruptcy filing because that payment that I mentioned is still going to be high. Like let's say they come to us and it's going to be, 1750 is what the private lender wants. Sorry about that, traffic.
That's okay.
1750 may be what the private lender wants. Well, if we get them down to 750, that may still not be affordable, even though it's going to be done in 4 years. So we might have to put them in a bankruptcy in order to have a lower payment over a longer period of time, again, with no or very little interest, so that loan is basically done with at a certain point.
Right. So strategically, if you file a Chapter 7 bankruptcy, are you seeing that you're able to get a lower payment, or you have more capabilities to get rid of the private student loans in a bankruptcy form?
Right. That's where it's fairly unique. It is pretty fantastic, the results that we're getting for private student loan discharge in bankruptcy. Basically, there's a lot of arguments. Back in 2005 and 6, we had the Bankruptcy Reform Act, and it made a lot of private student loans the same as federal, non-dischargeable. So there were lenders out there saying, well, I'd like to loan some money. I'd like it to be considered non-dischargeable. Let's approach students with these loans. We don't really care what the money's used for. We don't really care how much we loan them. It's non-dischargeable. They have a 40-year career in front of them. We will get paid. And so that's how the money got out there. The borrowers, the students, many of them felt, well, they won't lend me more than I can afford to repay, so I should probably take this. I need this for, different things. And it turns out that they can't repay. There's virtually no way, not with the interest that's on that loan. So what we can do is we can show that the loans were made outside the cost of attendance, which includes not only tuition, but books and supplies as well as room and board. Many of those loans were mixed. They were partially within, partially outside, or they were entirely extra, entirely outside that cost of education, cost of attendance. And every school has that published COA, even though it's a little bit on the hard side to find. So we can get rid of those loans. We can also get rid of loans for institutions that weren't eligible for federal funding. Most of the Caribbean medical schools, they weren't eligible for federal funding. And as it turns out, many folks weren't able to pass their boards, so they weren't able to practice as a physician. They're not making the kind of money they expected. They're not able to repay those loans. We can get rid of those. Um, a lot of other reasons might cause a school to be ineligible that we can file for. So we file what's called an adversary proceeding. We do that in a Chapter 7 bankruptcy. We can reopen an older bankruptcy. And in that, we allege, hey, by the way, these loans are dischargeable. They're outside the cost of attendance. They're to a non-eligible institution, whatever it is. And the interesting thing is this. If we reopen a bankruptcy, we have a tremendous collection stick that we can kind of hammer on. Because let's say that we win. Our win relates back to that bankruptcy they might have filed back in the foreclosure days. And so everything they've done in the meantime, every collection effort they've taken, every letter, every phone call, everything that they've done is potentially a contempt violation of the discharge order, as well as collection law violations. As you know, each state has different collection law violations. And so we can usually settle or completely discharge that debt if we're able to utilize a bankruptcy. And bankruptcy has another really significant plus, and that is any forgiveness that we have is completely tax-free. It's discharged. Discharged debt, as you know, has no taxable event. And that's one of the nice things about filing a bankruptcy. You don't have a tax bill from the IRS afterwards. Same thing for student loans, no tax bill. So we're able
Right.
to accomplish more in a bankruptcy. For those clients who have small debts, they owe 10, 20, 30,000, we can usually settle those outside of court. We don't need a bankruptcy for that. But when we're talking 75,000 or higher, often a bankruptcy ends up with a much better result for the client.
Right. And what's the impact on somebody's credit when they discharge the student loans like that in a bankruptcy?
Well, if it is done in a current bankruptcy, you know as well as I do that the bankruptcy stays on someone's record for 10 years, but most of the time they can rebuild their credit within about 2 years' time. And the last 18 months is the most important. So what we do is we tell folks, hey, if you're going to file a bankruptcy or you're going to put these loans into a settlement posture, if you have a car or house that you're trying to buy right now, maybe get the car or house first and then do this. Interestingly, if we're trying to reopen an older bankruptcy, has no impact on their credit whatsoever. That was all taken care of with the prior bankruptcy. We don't even care what the client makes right now. They could make anything that our argument is based on what happened in the prior bankruptcy, not what their salary is right now.
Right. And the real exciting thing, and you mentioned it briefly, is whether you're filing, if you have private student loans, and whether you're filing a new bankruptcy now or you filed a bankruptcy 10 years ago and you had private student loans, you can still reopen that case and perhaps take care of your student loans through that old bankruptcy. And at Miller, what we're doing now is I'm going through our hundreds of past Chapter 7 clients, taking a look at those and reaching out to people. In fact, I had a client that I referred to a few weeks ago that had filed a bankruptcy, I think back in 2016, and we're taking a look at that to see if there's anything that we can do to discharge or take care of the private student loan, even though the bankruptcy was a long time ago. Um, I want to just remind everybody that if you'd like to set up a consult with Christy or me, you can do that. Call 414-875-3816, or you can go to our website at millerlaw.com. Phone number again, 414-875-3816. You can message us on Facebook, but I would really urge everyone that has student loans to give us a call. There is definitely something that can be done. The landscape is changing, and I'm really excited that when someone calls and says they're having student loan issues, that we really have solutions and options for you. So give us a call, 414-875-3816. And Christy, thank you so much.
Absolutely.
You were just such great information, and I know you and I will be talking soon. Enjoy the Florida sun, and take care and stay healthy.
Thank you. And remember, everyone who has filed a bankruptcy before, please reach out to Jamie because we can do these new things that we couldn't do years before. And so you may have read or learned that your student loans are non-dischargeable in bankruptcy. That has really changed. And so it's something that you need to look at because this is a major thing to try to get rid of $20,000 to $100,000 of student loan debt. And it doesn't take very long. One thing we didn't talk about, Jamie, was how long, and it's usually less than 6 months, sometimes even 1 or 2 months. We had a attorney, for instance, that we moved her bankruptcy from Ohio down to Florida, and last week we settled for a full discharge within only about 2 weeks' time. So it was really, really fast. So thank you for the opportunity, Jamie. I really look forward to working with you and your clients, and I hope you have a great rest of the week. All
Thank
right,
you so much. I appreciate you.
bye-bye.